Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in my previous video we discussed two important theories as far as relationship between municipal laws and international laws are concerned, and in my this video we are going to discuss four important conflict theories pertaining to the municipal laws and international laws. Why to waste time? Let's get into the first slide. This is a common slide which we have already seen in my previous video also. The question is whether the municipal laws and international laws are one and the same, and for that we had two important theories which is already been discussed, that is the monistic theory and the dualistic theory. In this video we are going to discuss four important conflict theories. They are the specific adoption theory, the theory of transformation, the theory of delegation, and the theory of harmonization or the coordination. Let's try understand one by one the conflict theories. While discussing the conflict theories, one of the most important theory is theory of specific adoption. I have given two slides for this particular topic, and rest of the three conflict theories are discussed in just one slide. That way you can understand how important is theory of specific adoption, and there can be an independent question on theory of specific adoption also. So you need to give a lot of focus to this particular topic. Now, when we are implementing municipal law, there is no option with the individuals whether to accept the laws or not. They have to adopt to such laws. But when it comes to international law, the subject becomes state. Now, states are having option whether to adopt such laws or not. That is why we are calling it as theory of specific adoption, and the base for this theory is Hague Convention 1970, Vienna Convention 1972, and Tokyo Convention 1975. So basically international law is subject to specific adoption by each state, and we are going to see how exactly different states are adopting the international law with different examples. As a start of discussion, let us try understand how exactly we Indians are adopting international laws. The Indian Constitution article number 51, which is DPSP, discusses about promotion of international peace and security. And there are three important points which says the state shall endeavor to promote international peace and security, maintain just and honorable relationship between nations, and foster respect for international law and treaty obligations in the diligence of organized people with one another, and encourage settlement of international dispute by arbitration. By these three subclause, it gives sufficient importance, saying that we have to give a lot of importance to the international law by respecting each other to ensure that we have peace and security throughout the world, and we have obligations on international laws and treaty. Now, these are the very important aspects which are coming from Article 51, and let us see few important case laws what they have to see. In the Jolly George versus Bank of Cochin case, it was held that any agreement does not become part of Indian Constitution automatically, but the positive commitment of state parties inspires the legislative action. The second case law, Sri Krishna Sharma versus State of West Bengal, it was decided that whenever the court interprets the domestic municipal law, it should be taken into consideration that it does not go against international law. The third case law, that is Meghabhai Ishwarbhai Patel versus Union of India, court accepted that the implementation of Kutch agreement between India and Pakistan on the basis of correspondence between them. The different other case laws that you can refer is Vishaka versus State of Rajasthan or Apparel Export Promotion Council versus AK Chopra. The British adoption of international law is very interesting. You have to understand it in two different parts. One, the international customs. The second one, the treaties. When it comes to international customs, the international customs are treated as part of the domestic law of British, whereas treaties are not binding automatically in England. Now, one important thing which makes international custom not part of the British law if it is inconsistent with the domestic law of them. Otherwise, they are directly considering them as the part of their domestic law. But when it comes to treaties, they have their own reservations, which was discussed in the case law of International Tin Council versus Department of Trade and Industry, where the Lord Council decided that in England, treaties are not binding automatically. It is binding only when the Parliament makes it a part of English law and incorporates in law by enactment of law in this regard. That means the treaties will not become automatically laws in England unless and until it is passed by them. whereas the international customs are mostly treated as part of domestic law till the time they are consistent with their domestic laws. American adoption is much more interesting. There the state laws interpreted in such a way that it doesn't go against international law. They have formed their laws according to the international laws, and in the Havana case it was held that the international law is part of our state law, and when any question or case relating to international law is filed before the courts of proper power, then the rights based on these questions should be determined and enforced. So they are giving sufficient importance to international law. That is how they are adopting the international laws. The second theory is theory of transformation. Now, not every single law of international law can be considered as municipal law. It needs to be transformed based on the requirement of the state, and the process is given a lot of importance here. And that is what Starkey also says, that the rules of international law can be applied when they are transformed into domestic law is not necessary in every case. It may happen or it may not happen. That is what they are discussing when it comes to transformation, which is a process. It is not by force or by adopting. It can happen only through transformation, that the international law transforms into a domestic law. The third theory is theory of delegation. This is basically a part of monism theory, which believes that international laws and the municipal laws are one and same. International law basically delegates its power to state. That is what this theory believes in. And it says the international laws are given to the state, and it is the state which adopts the same and implements that as municipal law, which is what this theory is all about. And the case law for that is US versus Pink, where it was held that by the Supreme Court of US that an international treaty is a law of the land under the supremacy clause of the US Constitution. The last theory is harmonization or coordination theory, which believes that there should not be any clash between international law and municipal law. There can be, or they can be harmonized. That is what this theory believes in. And Professor Nebuet said that these two forces never meet. They are not like a gear, but like two wheels revolving upon the same axis. That is what they are saying. So this is all about getting harmonized. The international law getting harmonized with the state law, which is what the fourth theory. As far as exams are concerned, the second, third and fourth theories are not that important. But the first theory, which is specific adoption theory, can be an independent question, and you might get a question on Indian adoption or English adoption or American adoption as an independent question also. So give a lot of importance to that particular portion. And with that, I am concluding this particular video. Please subscribe my channel. Please like, share and comment my videos. All the very best for whatsoever purpose you are watching my channel, and thanks again.